Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Turkiye Halk Bankasi A-S v. United States. In this case, the court considered this issue: may the district courts properly exercise subject matter jurisdiction over the criminal prosecution against Halkbank in this case, based on the commercial activity exception to the Foreign Sovereign Immunities Act. The case was decided on April 19, 2023. The Supreme Court held that the district court has jurisdiction. In this criminal prosecution, the Foreign Sovereign Immunities Act's comprehensive scheme governing claims of immunity in civil actions against foreign states and their instrumentalities does not cover criminal cases. Justice Brett Kavanaugh authored the 7-2 majority opinion of the court. 18. U.S.C. Section 3231 contains a broad jurisdictional grant. It gives district courts original jurisdiction over all offenses against the laws of the United States. Absent a textual exclusion of foreign states, the most natural reading of that provision is that it includes them. The Foreign Sovereign Immunities Act covers only civil cases. It grants district courts original jurisdiction over any non-jury civil action against a foreign state as to any claim for relief in personam with respect to which the foreign state is not entitled to immunity, and describes procedures and remedies applicable exclusively in civil, not criminal cases. Shaw is silent as to criminal prosecutions. It's one provision that a foreign state shall be immune from the jurisdiction of the courts of the United States, and of the states except as provided in sections 1605 to 1607 of this chapter must be read in conjunction with the rest of the Act, which focuses exclusively on civil matters. However, principles of common law immunity might preclude this criminal prosecution even if the FIA does not. Thus, the court affirmed the appellate court's determination that the district court had jurisdiction, reversed as to its conclusion that FIA granted immunity from criminal prosecution, and vacated and remanded as to the issue of common law immunity claims. Justice Neil Gorsuch authored an opinion concurring in part and dissenting in part, joined by Justice Samuel Alito. Justice Gorsuch argued that Fiji alone dictates the answer to the immunity questions in this case, and thus agrees with the majority as to all but the judgment to vacate and remand the question of common law immunity. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Kavanaugh delivered the opinion of the court. The United States indicted Halkbank, a bank owned by the Republic of Turkey, for conspiring to evade U.S. economic sanctions against Iran. The United States brought the prosecution in the U.S. District Court for the Southern District of New York. Halkbank contends that the indictment should be dismissed because the General Federal Criminal Jurisdiction Statute, 18 U.S.C. Section 3231, does not extend to prosecutions of instrumentalities of foreign states such as Halkbank. Halkbank alternatively argues that the Foreign Sovereign Immunities Act of 1976 provides instrumentalities of foreign states with absolute immunity from criminal prosecution in U.S. courts. We disagree with Halkbank on both points. We hold that the district court has jurisdiction under 18 U.S.C. Section 3231 over the prosecution of Halkbank. We further hold that the Foreign Sovereign Immunities Act does not provide immunity from criminal prosecution. With respect to an additional common law immunity argument raised by Halkbank, we vacate the judgment of the Court of Appeals and remand. Halkbank is a bank whose shares are majority owned by the Turkish Wealth Fund, which in turn is part of and owned by the Republic of Turkey. In 2019, the United States indicted Halkbank for a multi-year conspiracy to evade economic sanctions imposed by the United States on Iran. The indictment alleged that Halkbank, with the assistance of high-ranking Turkish government officials, laundered billions of dollars of Iranian oil and gas proceeds through the global financial system, including the U.S. financial system, in violation of U.S. sanctions and numerous federal statutes. The indictment further claimed that Halkbank made false statements to the U.S. Treasury Department in an effort to conceal the scheme. Two individual defendants, including a former Halkbank executive, have already been convicted in federal court for their roles in the alleged conspiracy. According to the U.S. government, several other indicted defendants, including Halkbank's former general manager and its former head of foreign operations, remain at large. Halkbank moved to dismiss the indictment on the ground that an instrumentality of a foreign state such as Halkbank is immune from criminal prosecution. Under the Foreign Sovereign Immunities Act of 1976, 28 U.S.C. Sections 1330, 1602 et seq., the U.S. District Court for the Southern District of New York denied the motion, reasoning in relevant part that the FIA does not appear to grant immunity in criminal proceedings. Halkbank filed an interlocutory appeal, and the U.S. Court of Appeals for the Second Circuit affirmed. The Court of Appeals first determined that the District Court has subject matter jurisdiction over this criminal prosecution under 18 U.S.C. Section 3231. As to the fee, the Court of Appeals assumed without deciding that the FIA confers immunity in criminal proceedings to foreign states and their instrumentalities, but held that in any event Halkbank's charged conduct fell within the FIA's exception for commercial activities. We granted certiorari. Halkbank first contends that the district court lacks jurisdiction over this criminal prosecution. Section 3231 of Title 18 provides, "The district courts of the United States shall have original jurisdiction, exclusive of the courts of the states, of all offenses against the laws of the United States." Via its sweeping language, Section 3231 opens federal district courts to the full range of federal prosecutions for violations of federal criminal law. By its terms, Section 3231 plainly encompasses Halkbank's alleged criminal offenses, which were against the laws of the United States. Halkbank cannot and does not dispute that Section 3231's text as written encompasses the offenses charged in the indictment. Halkbank nonetheless argues that the statute implicitly excludes foreign states and their instrumentalities. In support of that argument, Halkbank identifies certain civil and bankruptcy statutes that expressly refer to actions against foreign states and their instrumentalities. Because Section 3231 refers generically to all federal criminal offenses without specifically mentioning foreign states or their instrumentalities, Halkbank reasons that foreign states and their instrumentalities do not fall within Section 3231's scope. We decline to graft a textual limitation onto Section 3231's broad jurisdictional grant over all offenses, simply because several unrelated provisions in the U.S. Code happen to expressly reference foreign states and instrumentalities. Those scattered references in distinct context do not shrink the textual scope of Section 3231, which operates without regard to the identity or status of the defendant. Halkbank also points to Section 3231's predecessor, a provision of the Judiciary Act of 1789 granting district courts cognizance of all crimes and offenses that shall be cognizable under the authority of the United States. In Halkbank's view, other statutory provisions from that same era, including several that referred to suits against foreign actors, suggest that Congress would have expressly referenced foreign states and their instrumentalities if Congress had intended the 1789 provision to reach those entities. And Halkbank says that we should read Section 3231 like its predecessor provision. The premise is unsupported. The 1789 provision, like Section 3231 itself, contains no exception for prosecutions of foreign states or their instrumentalities, and this court has never suggested that the 1789 provision contains an implicit exception. So the 1789 provision does not help Halkbank's argument that we should find an implicit exception in Section 3231. Finally, Halkbank invokes a separate provision of the 1789 Judiciary Act granting district courts jurisdiction over all civil causes of admiralty and maritime jurisdiction. Halkbank asserts that this court has construed that provision not to confer jurisdiction over foreign state entities. It follows, Halkbank says, that the 1789 Act's similar general reference to all crimes and offenses, and its successor, Section 3231's reference to all offenses, likewise must be interpreted not to reach foreign states and their instrumentalities. We disagree with Halkbank's reading of our precedents. The case on which Halkbank primarily relies, Schooner Exchange, indeed held that a district court lacked jurisdiction over a suit claiming ownership of a French warship docked in a Philadelphia port. But Schooner Exchange did not address statutory subject matter jurisdiction. Instead, as this court has since explained, Schooner Exchange concerned principles of foreign sovereign immunity that developed as a matter of common law. Contrary to Halkbank's contention, the common law sovereign immunity recognized in Schooner Exchange is a rule of substantive law governing the exercise of the jurisdiction of the courts, not an exception to a general statutory grant of subject matter jurisdiction. In sum, the district court has jurisdiction under 18 U.S.C. Section 3231 over this criminal prosecution. Relying on the Foreign Sovereign Immunities Act, Halkbank contends that it enjoys immunity from criminal prosecution. We disagree because the Act does not provide foreign states and their instrumentalities with immunity from criminal proceedings. The doctrine of foreign sovereign immunity originally developed in U.S. courts as a matter of common law rather than by statute. In determining whether to allow suits against foreign sovereigns, however, courts traditionally deferred to the decisions of the political branches, in particular, those of the executive branch. In 1952, the State Department announced the restrictive theory of foreign sovereign immunity, under which immunity was typically afforded in cases involving a foreign state's public acts, but not its strictly commercial acts. In the ensuing years, the process by which the executive branch submitted statements regarding a foreign state's immunity sometimes led to inconsistency, particularly in light of the case-by-case diplomatic pressure that the executive branch received from foreign nations. And when foreign states did not ask the State Department to weigh in, courts were left to render immunity rulings on their own, generally by reference to prior State Department decisions. In 1976, Congress entered the fray and sought to standardize the judicial process with respect to immunity for foreign sovereign entities in civil cases. Congress passed, and President Ford signed the Foreign Sovereign Immunities Act. The FSIA prescribed a comprehensive set of legal standards governing claims of immunity in every civil action against a foreign state. To that end, the FIA codifies a baseline principle of immunity for foreign states and their instrumentalities. 28 U.S.C. Section 1604. The FIA then sets out exceptions to that principle, including, for example, the exception for commercial activities. The FIA defines a foreign state to encompass instrumentalities of a foreign state, including entities that are directly and majority owned by a foreign state. In this case, the United States does not contest Halkbank's status as an instrumentality of a foreign state for purposes of the FIA. Since the FIA's enactment, this court has repeatedly stated that the statute applies in civil actions. Although the court has not expressly held that the FIA covers only civil matters, the court has never applied the Act's immunity provisions in a criminal case. We now hold that the FIA does not grant immunity to foreign states or their instrumentalities in criminal proceedings. Through the FIA, Congress enacted a comprehensive scheme governing claims of immunity in civil actions against foreign states and their instrumentalities. That scheme does not cover criminal cases. To begin with, the text of the FIA indicates that the statute exclusively addresses civil suits against foreign states and their instrumentalities. The first provision of the FIA grants district courts original jurisdiction over any non-jury civil action against a foreign state, as to any claim for relief in personam with respect to which the foreign state is not entitled to immunity. The FIA then sets forth a carefully reticulated and detailed set of procedures governing civil actions in U.S. courts against foreign states and their instrumentalities. For example, the FIA specifies procedures for obtaining jurisdiction over a foreign state in a civil action, which require a summons and complaint that must be addressed and dispatched to the foreign state according to detailed protocols. The FIA further explains how U.S. courts should handle default judgments entered against foreign states in civil actions, including by requiring plaintiffs to establish their claim or right to relief by evidence satisfactory to the court. In addition to the textual evidence indicating that the FIA applies only in civil actions, the FIA's statutory history reveals that the Act was animated by concerns about the treatment of foreign states and their instrumentalities in civil litigation. The preamble to the House report, for example, recounts a series of civil lawsuits against foreign states and concludes that the FIA is needed to fill the need for a comprehensive statute containing standards governing when and how foreign sovereign immunity should be granted or denied in civil actions. The Senate report similarly frames the Act as a means to set forth comprehensive rules governing sovereign immunity as an aspect of substantive law in actions brought in the courts of this country. The Senate report adds that the Act would enable a private plaintiff to assert a legally justified claim against a foreign state in a federal court. On balance, the text and history of the FIA do not support Halkbank's argument that the FIA grants immunity to foreign states and their instrumentalities in criminal matters. By way of comparison, other FIA provisions likewise reinforce that the Act applies only to civil actions. The FIA's venue provision underscores the statute's focus on civil cases. That provision instructs that a civil action against a foreign state is to be brought in one of 4 specific venues, including the district where a substantial part of the events or omissions giving rise to the claim occurred. At the time the FIA was enacted, Congress had prescribed a materially similar set of venues for federal civil litigation, but not for criminal prosecutions. Moreover, FIA's removal provision directs foreign state defendants to follow procedures applicable to civil cases by requiring removal in the same manner as a defendant in an action brought in a state court. No comparable statute governed removal of criminal prosecutions at the time the FIA was enacted. By contrast, other statutes related to foreign sovereign immunity expressly address both civil and criminal matters. The Vienna Convention on Diplomatic Relations, for example, extends its immunity to a criminal, civil, or administrative proceeding, but the FIA exclusively addresses civil actions against foreign states and their instrumentalities. Finally, practical considerations reinforce that the FIA does not apply to criminal matters. For example, Congress has established various statutes of limitations for civil claims against foreign states and instrumentalities, but criminal statutes of limitations are entirely different, and the FIA's silence about criminal statutes of limitations confirms that Congress did not intend the FIA to apply to criminal matters. Moreover, if the FIA were to apply to criminal cases, then the venue and removal provisions, which are tailored to civil cases, would need to be rewritten to account for criminal prosecutions. In short, the FIA's text, context, and history establish that the Act does not grant immunity to foreign states and their instrumentalities in criminal matters. Halkbank separately contends that it is entitled to immunity under the common law. In particular, Halkbank argues that even if the FIA does not apply, pre-FIA common law immunity principles shield instrumentalities of foreign states such as Halkbank from criminal prosecution. The Court of Appeals did not address that argument because it held that Halkbank's charged conduct fell within the FIA's commercial activities exception. We vacate the judgment of the Court of Appeals and remand for the Court of Appeals to consider Halkbank's common law immunity argument in the first instance. For the reasons stated, we affirm in part and vacate in part the judgment of the U.S. Court of Appeals for the Second Circuit, and we remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Gorsuch, with whom Justice Alito joins, concurring in part and dissenting in part. For almost a half-century, judges have known where to turn for guidance when deciding whether a foreign sovereign is susceptible to suit in an American court. Congress's directions in the Foreign Sovereign Immunities Act of 1976, FSIA. Sometimes the FIA authorizes American courts to hear cases against foreign sovereigns. Sometimes the statute immunizes foreign sovereigns from suit. Today, however, the court holds that the FIA's rules apply only in civil cases. To decide whether a foreign sovereign is susceptible to criminal prosecution, the court says, federal judges must consult the common law. Respectfully, I disagree. The same statute we routinely use to analyze sovereign immunity in civil cases applies equally in criminal ones. I begin from common ground. Congress has vested federal courts with subject matter jurisdiction over cases involving offenses against the laws of the United States. The court holds that this statute permits federal courts to hear cases alleging offenses committed by foreign sovereigns. I agree. As the court explains, the statute's language grants subject matter jurisdiction in broad terms without regard to the nature of the defendant, nor are we free to graft in a textual limitation onto the law that would exempt foreign sovereigns from its reach. Of course, Turkiye Halk Bankasi, Halkbank, asserts that it is a sovereign entity and as such, enjoys immunity from prosecution. But that does not change a thing. Generally, questions about sovereign immunity do not go to a court's subject matter jurisdiction, something a court must consider in every case even if the parties do not. Instead, questions of sovereign immunity usually go to a court's personal jurisdiction over a particular defendant. And, as with other personal jurisdiction defenses, a sovereign may waive its immunity and consent to judicial proceedings if it wishes. From that common ground, however, I part ways with the court. Like the Second Circuit, I would analyze Halkbank's assertion of sovereign immunity under the terms of the FIA. Start with the FIA's general immunity rule. It provides in relevant part that a foreign state shall be immune from the jurisdiction of the courts of the United States and of the states, except as provided in sections 1605 to 1607 of this chapter. Elsewhere, the statute defines a foreign state to include an agency or instrumentality of a foreign state, and the statute defines an agency or instrumentality to include any separate legal person, such as a corporation, that is an organ or subdivision of a foreign state and majority owned by a foreign state. Applying those rules here yields a ready answer. Halkbank is a corporation that is majority owned by the government of Turkey. Accordingly, it qualifies as a foreign state entitled to immunity from suit under the general immunity rule, unless one of the exceptions provided in the statute applies. And, it turns out, one such exception does apply. The statute instructs that a foreign sovereign is not entitled to immunity when the action is based upon certain commercial activity in or affecting the United States. In this case, the indictment sufficiently alleges that Halkbank has engaged in just those kinds of commercial activities. Of course, this case comes to us on a motion to dismiss the indictment, and the question of immunity may be revisited as the case proceeds. But for now, nothing in the law precludes this suit, just as the Second Circuit held. That the FIA tells us all we need to know to resolve the sovereign immunity question in this case can come as no surprise. This court has long acknowledged that the FIA must be applied by the district courts in every action against a foreign sovereign. As we have put it, any sort of immunity defense made by a foreign sovereign in an American court must stand on the Act's text, or it must fall. It's a rule that follows directly from the statutory text, because Congress established in the SCI a comprehensive framework for resolving any claim of sovereign immunity. 2. Despite all this, the court declines to apply the FIA's directions governing foreign sovereign immunity. It holds that the statute's general immunity rule speaks only to civil disputes. Any question about a foreign sovereign's immunity from criminal prosecution, the court insists, must therefore be resolved under common law principles. In aid of its conclusion, the court offers three principal arguments, but to my mind, none packs the punch necessary to displace the plain statutory text. First, the court points to another provision of the statute. That provision grants federal courts subject matter jurisdiction over civil cases against foreign sovereigns when one of the exceptions provided applies. From this grant of civil jurisdiction, the court reasons, it is a natural inference that the statute's immunity rule must apply only in civil cases. More naturally, however, it seems to me that any inference from this provision runs the other way. This provision shows that when Congress wanted to limit its attention to civil suits, it knew how to do so. The immunity rule contains no similar language restricting its scope to civil disputes. Instead, it speaks far more broadly, holding that a foreign state shall be immune unless a statutorily specified exception applies. Normally, when Congress includes limiting language in one section of a law but excludes it from another, we understand the difference in language to convey a difference in meaning. The court's interpretation of the SCI defies this traditional rule of statutory construction. Today, the court does to the immunity rule exactly what it recognizes we may not do to the general jurisdiction provision, grafting in a textual limitation onto the law's unambiguous terms, in this instance, adding a civil-only restriction. Second, the court suggests we should read the immunity rule as affording immunity only in civil cases, because the statute's exceptions apply only in civil cases. But here both the premise and the conclusion seem to me mistaken. If some of the statute's exceptions apply only in civil cases, others speak more expansively. Take the exception relevant here. The commercial activities exception found in the statute denies sovereign immunity in any case, in which the action is based upon a commercial activity carried on in the United States by the foreign state. Nowhere does this exception distinguish between civil and criminal actions. Besides, even if the court's premise were correct and the statute's exceptions, somehow, applied only in civil actions, what would that prove? It might simply mean that Congress wanted a more generous immunity from criminal proceedings than civil suits. Finally, the court points to the FIA's provisions regulating the venue and removal of civil actions against foreign sovereigns. But once more, it seems to me this shows only that Congress knew how to speak specifically to civil suits when it wished to do so. Congress may have had reason to be especially concerned about the venue for civil suits too, given that almost all efforts to hail foreign sovereigns into U.S. courts have involved civil claims. Indeed, the parties and their amici struggled to find examples of criminal charges brought against foreign sovereigns either before or after the FIA's adoption, not only in the United States, but in any country. I might be willing to spot the court that the venue and removal provisions could help illuminate the immunity rule's scope if that statute were ambiguous. But no one suggests that we have anything like that here. The immunity rule is as clear as a bell, and we must abide by its direction that foreign sovereigns shall be immune, absent some express statutory exception. After declaring that the FIA applies only to civil suits, the court holds that the common law controls the disposition of any claim of foreign sovereign immunity in criminal cases. Yet rather than decide whether the common law shields Halkbank from this suit, the court shunts the case back to the Second Circuit to figure that out, all of which leaves litigants and our lower court colleagues with an unenviable task, both in this case and others sure to emerge. Many thorny questions lie down the common law path, and the court fails to supply guidance on how to resolve any of them. Right out of the gate, lower courts will have to decide between two very different approaches. One option is to defer to the executive branch's judgment on whether to grant immunity to a foreign sovereign, an approach sometimes employed by federal courts in the years immediately preceding the FIA's adoption. The other option is for a court to make the immunity decision looking to customary international law and other sources. Whichever path a court chooses, more questions will follow. The first option, deferring to the executive, would seem to sound in separation of powers concerns. But does this mean that courts should not be involved in making immunity determinations at all? And what about the fact that the strong deference cases didn't appear until the 20th century? Were courts acting unconstitutionally before then? If not, should we be concerned that deference to the executive's immunity decisions risks relegating courts to the status of potted plants, inconsistent with their duty to say what the law is in the cases that come before them? The second option, applying customary international law, comes with its own puzzles. If the briefing before us proves anything, it is that customary international law supplies no easy answer to the question whether a foreign sovereign enjoys immunity from criminal prosecution. Nor is it even altogether clear on what authority federal courts might develop and apply customary international law. Article 6 of the Constitution does not list customary international law as federal law when it enumerates sources of the supreme law of the land. And Article I vests Congress rather than the judiciary with the power to define and punish offenses against the law of nations. Perhaps Article 3 incorporated customary international law into federal common law, but since Erie Railroad Company v. Tompkins, federal courts have largely disclaimed the power to develop federal common law outside of a few reserved areas. And whether customary international law survives as a form of federal common law after Erie is a matter of considerable debate among scholars. Must lower courts confront this long-running debate to resolve a claim of foreign sovereign immunity in criminal cases? And if there is no federal law at work here that might apply under the Supremacy Clause, only general common law principles, what constraints remain on state prosecutions of foreign sovereigns? Today's decision overcomplicates the law for no good reason. In the FIA, Congress supplied us with simple rules for resolving this case and others like it. Respectfully, I would follow those straightforward directions to the same straightforward conclusion the Second Circuit reached. This case against Halkbank may proceed. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.